So now I'm talking about governance in AI. So AI refers to a range of technologies which can be used for both harm and good. Governing the use of AI is driven by the need to minimize risks and harms. While AI has been around for many decades, over the last decade, five major developments have brought AI to households and consequently into the lexicon of policymaking, regulation, and governance. First is significant technological progress in the field of ML, access to much larger data sets for the purpose of training AI systems, advancements in computation performance and scale, advancement in natural language processing NLP and capabilities, and also widespread availability of connected devices to deliver apps employing AI systems to users at scale. So the combination of these factors has given rise to a new paradigm for developing and deploying AI systems. The creation of foundation models that, after being trained on a huge amount of broad data, can be adapted to many applications, including generative AI tools, accessible to end users to perform a variety of tasks. Right. So some governance principles I'll be discussing. So since 2016, several organizations from government, industry, and civil society have published principles for responsible and trustworthy AI, that is RTAI. These set out a vision for development, deployment, and the use of AI systems that should inform the design of regulation of such systems as well. So basically, a proposed list of AI governance principles with their explanation is given below. The list is aligned with the OECD, NITI, and NITI Aayog and NASCOM efforts. So first is transparency. The AI systems should be accompanied with the meaningful information, and should be interpretable and explainable as appropriate. Users should know when they are dealing with an AI. Accountability. Developers and deployers should take responsibility for the functioning and outcomes of AI systems and for the respect of user rights, the rule of law, and the above principles. Right? Mechanisms should be in place to clarify accountability. Then safety, reliability, and robustness. So AI systems should be developed, deployed, and used in a safe, reliable, and a robust way so that they are resilient to risks, errors, or inconsistencies. The scope for misuse and inappropriate use is reduced, and unintended or unexpected adverse outcomes are identified and mitigated. Right? AI systems should be regularly monitored to ensure that they operate in accordance with their specifications and perform their intended functions. Moving on, privacy and security. So, AI systems should be developed, deployed, and used in compliance with applicable data protection laws and in ways that respect users' privacy. Mechanisms should be in place to check the data quality, data integrity, and security by design as well. Now, fairness and non discrimination. So, AI systems should be developed, deployed, and used in ways that are fair and inclusive to and for all, and that do not discriminate or perpetuate biases or prejudices against or preferences in favor of individuals, communities, or groups. Now, human centered values and do no harm. So, the AI systems should be subject to human oversight, judgment, and intervention as appropriate to prevent undue reliance on AI systems and address complex ethical dilemmas that such systems may encounter. Mechanisms should be in place to respect the rule of law and mitigate adverse outcomes on society. Moving on to the seventh point, that is inclusive and sustainable innovation. So, the development and deployment of AI systems should look to distribute the benefits of innovation equitably. AI systems should be used to pursue beneficial outcomes for all and to deliver on SDGs, that is, Sustainable Development Goals. Also, digital by design governance. So, the governance of AI systems should leverage digital technologies to rethink and also re engineer the systems and processes for governance, regulation, and compliance to adopt appropriate technological and techno legal measures as may be necessary to effectively operationalize these principles and to enable compliance with applicable law. Now, moving on, considerations to operationalize the principles. So, the subcommittee has identified three key concepts that inform the operationalization of the principles and underpin AI governance in India. So, examining AI systems using a life cycle approach. So, a life cycle approach to the development, deployment, and the use of AI systems is useful to examine putting the principles into practice effectively. This is because the risks of AI systems play out very differently at different stages in a life cycle of a given AI system, and it's useful to think in terms of three broad stages. First is development, which involves examining the design, training, and testing of a given system. Second is deployment, which involves examining and putting of a given AI system into actual operation and use. And diffusion is which involves taking a long-term view and examining the implications on of multiple AI systems being widely deployed and used across multiple sectors and industries. Now, governance efforts should consider the entire lifecycle when operationalizing the set of principles. Then, taking the ecosystem view of AI actors. So, multiple actors can also be involved across the lifecycle of an AI system. Together, they create an ecosystem. For example, in the context of the lifecycle of a foundation model, we have multiple actors, that is, data principals, data providers, vendors, AI developers, including the model builders, AI deployers, including app builders and distributors, that is, vendors, then end users, including both businessmen and the citizens, businesses and citizens. So, that's about the ecosystem with the AI actors. And then we have the basically technology for governance, which you can read through, right? Now, moving on, we have this gap analysis. So AI systems do not have agency except to the extent we can afford them. To the extent we afford them. In undertaking a gap analysis, the subcommittee kept in perspective the fact that existing laws and regulations continue to apply to the use of AI. The principles of responsible AI, including with respect to safety, equality, transparency, inclusivity, privacy, non discrimination, are grounded in the fundamental rights enshrined in our Constitution. Given this, there is need to examine the suitability of existing laws to deal with the risks and harms in the context of AI systems, which can provide a meaningful direction to strengthen our governance framework. So the subcommittee focused on identifying the gaps taken into consideration that where AI systems can be used to exasperate well understood harms, there is a need to prioritize efforts that enable the effective compliance and enforcement of existing laws. To govern effectively, regulators will first need access to adequate information about the dynamics of the overall AI ecosystem of data, models, apps, actors, users, AI systems, etc. And since the field of AI is rapidly evolving and AI systems are increasingly cross cutting tools, there's a need for a whole of government approach to deal with emerging risks of harm. So basically, the subcommittee discussed a few other topics which may require policy position or no action or further observation, right? So the three considerations mentioned above are discussed in detail below. That is the need to enable effective compliance and enforcement of existing laws, deepfakes, fakes, or malicious content. There are existing legal safeguards or instruments to protect against misuse of foundation models for creating malicious synthetic media, that is malicious deepfakes. In this case, depending upon the context and negative effect of the malicious synthetic media in question, multiple laws can apply. For example, the IT Act of 2000. So, Section 66D of the IT Act criminalizes the use of computer resources for cheating by personation. Section 66E prescribes the punishment for capturing and publishing or transmitting the image of a private area of any person without his or her consent. Publishing or transmitting obscene material, for instance, which could be generated by using deepfake technology, is also a punishable offense under Section 67A and 67B of the IT Act. Then IPC, Indian Penal Code. In addition to the IT Act, certain harms or cybercrimes perpetuated by AI could also fall under the IPC. For example, identity theft and cheating by personation are offenses under Section 419, cheating by personation. Then Section 463 and 465, that is forgery for the purpose of cheating. Section 292 and 294, selling, circulating, distributing obscene objects. And Section 499, causing harm to reputation or defamation. It is to be noted that the IPC has been recently replaced by the Bharatiya Nyaya Second Sanhita BNS2, and the BNS2 retains these offenses, right? And we also have acts like POXO Act, that's Prevention of Children from Sexual Offences Act 2012, in the event of sexual harassment of children, then juvenile justice for causing harm to the children, and the Copyrights Act if synthetic content infringes copyrighted work, right? So that's about that part. And then we have cybersecurity rules that you can read through.